afternoon, everyone. As you can see, I am not Lynn. I am Liza Lovdahl Gormsen, and I will be chairing this panel instead of Lynn. And this panel is on privatization of privacy, freedom and democracy, and the threat of global tech monopolies. And some of you may have seen George Soros. He gave a speech at Davos last night where he talked about the threat of Facebook and Google and that those companies hold too much power and that is a threat to our democracy. And this is exactly what we'll be talking about on this panel today. We have an hour and 15 minutes, and the way I'm going to conduct this panel is by allowing each speaker to have 5 to 7 minutes. And then I'll have my moderator, which is Orla Lynsky, who is sitting on my right, to ask questions to each individual speaker. So I'm just going to introduce the speakers and the running order. So we'll have Orla Lynsky from the London School of Economics. She will be moderating this panel. And Lynn from the Open Markets Institute in the US, he will introduce the problem of this panel. And then we have Maurice Stucke, who is a professor at University of Tennessee College of Law and of counsel at the Congruence Group. And he will be discussing competition amongst the GAFA companies and how their personal digital assistants, such as Google Home and Amazon Alexa, their network effects and how that affects the market, the economic, social, and political implications, including privacy concerns, if we have a dominant digital assistant. And after Maurice, we'll have Lina, who is from University of Yale in the US, sitting just to my right. And she will focus on the asymmetry of information and concentration of business data, not just personal data, and how this is being used to thwart innovation. And she argues for a structural separation, and she will be discussing these separations in US law. And finally, but not least, I have Christian Dacuna at my immediate left, who is from the European Data Protection Supervisor, and he will be discussing how data is invading the private sphere. And he argues that data protection is a privacy issue, and more needs to be done to stop accumulation and concentration in the economy, and finally, what regulators should be doing. So, Orla, over to you.
Thanks, Lisa. Good afternoon, everybody. Well, just to kick things off, you might be wondering why we're sitting here with a bunch of competition lawyers at a data protection conference. So I think the first thing we need to do, and Barry will elaborate on this further, but is to consider the links between data protection and competition law. And I think we can probably say that last year was the first year where competition lawyers really sat up and started to take notice of data protection law and of privacy as a potential competitive concern. So for those of you who aren't yet familiar with the broad contours of that discussion, I think there are a few ways in which you can see that competition law and data protection do intersect. So first of all, if you think of competition law as shaping the markets on which data protection regulation applies and the markets in which data processing occurs. And so broadly speaking, there are 3 ways in which competition law then can influence the effectiveness of the data protection rules. So first of all, there's a big discussion about the monopoly power of technology companies and whether or not that monopoly power allows tech companies to extract exploitative data processing conditions from us as individuals. And so this has been, I guess, pushed to the forefront by the German Competition Authority, which in December indicated that it's going to take preliminary proceedings against Facebook for the way in which it extracts personal data from individuals. And in particular, it's considering whether Facebook has abused its position of market power as a result of the conditions it offers for personal data processing. So you can really see there how that is at once a competition issue, but also something that we could consider under the General Data Protection Regulation or the Data Protection Directive even at present. You might also think here of data-driven mergers. So in the UK this week, we've seen that the takeover of Sky has been put on hold. We can talk about that perhaps a bit later, because the merger might have an impact on the public interest. It's a media merger. Should we have similar provisions, public interest provisions, that apply for data-driven mergers? So if Facebook takes over WhatsApp, as it has done, is that more than an economic issue? It is, of course, a competition issue, but does it also raise data protection concerns? And should competition authorities be alive to those concerns before they give that type of merger a stamp of approval? And then finally, more broadly speaking, we could say that the type of personalization that we're seeing on the internet these days and across all technological devices is facilitated by data. And while in the data protection world, we're having discussions about the benefits and drawbacks of that personalization and the extent to which it's captured by the GDPR, in the competition world, there's a parallel discussion about whether or not access to personal data, or data more generally, constitutes a barrier to entry. So is it possible for us to imagine a competitor to Google, for instance, once Google has amassed a critical quantity of personal data? So that's just to set the scene somewhat, but I'm going to pass the floor now to Barry, who will speak to these issues a bit more. Because of course they're economic, they're data protection issues, but they are also societal issues with political impact, as we'll also discuss on this panel.
Thanks, Orla, and thanks, Lisa. As Lisa mentioned, I'm Barry Lynn. I'm not the chair of this program. What I am is I run an organization called Open Markets, which is a Open Markets Institute, and it's based in Washington. It's a new think tank. We used to run we used to be a program within the New America Foundation. As some of you may know, we were kicked out of New America Foundation at the end of last summer for taking on Google. And we're now independent and we're growing, and we're actually quite happy with our situation. My job today is to kind of provide a big picture, sort of a sense of, where we are as a society, here in Europe, in the United States. It's really simple. The big picture is that we see an absolutely unprecedented concentration of power in our political economy. In many ways, it's worse than it was 100 years ago at the time of the Gilded Age. This concentration of power has really taken place in two stages. The first stage was due to changes in how we enforce anti-monopoly law. And that was something that happened in the late 70s and early 80s. This was the neoliberal revolution, the libertarian revolution, the Chicago School Revolution. That disrupted how we do anti-monopoly law, both in the United States and in Europe, and had unleashed concentrations of power across the political economy. The second stage was due to the fact that we've seen a technological revolution take place within this new environment of law that was created by the change in philosophy back 35 years ago. And this was the rise of the digital economy, the digital powers like Google and Facebook and Amazon. The problem with companies like Google, Facebook, and Amazon, with corporations like Google, Facebook, and Amazon, is not so much their size, it's their control. It's the power that they have over us. Now, these companies, as we're seeing, are fast emerging as kind of the central regulators, the masterminds within our political economy, within our society. This is a direct threat to our democracy. It is a direct threat to our most important personal liberties. Now, it's important, I think, as we sort of talk about markets, and we're going to all be talking about the structure of markets, is to maybe have an image of what a market looks like. And just to give you, I'm going to tell a little story about the book market in the United States to give you this image that we can use later. 35 years ago in the United States, on one side of the book market, you had a whole bunch of people who were authors. And then you had dozens and hundreds of companies that were publishers. Then you had thousands and thousands of retailers. And on the other side of the market, you had millions of readers. Jump ahead to today. You have a single company, Amazon, that stands in the middle of this interrelationship between the citizen as author and the citizen as reader. 35 years ago, an idea, a book, could go through an infinite number of pathways to get to from the author to the reader. Today, by contrast, because we have allowed a single intermediary to stand in between, that intermediary pretty much controls all interactions between authors and readers. And it has control over every single publisher, over every single author in the United States. It has the ability to shunt and direct readers away from books they might want to read to books that they don't want to read. Amazon is now the largest publisher of books in the United States. It got that way because it basically has taken advantage of its power as the intermediary to steal business from other companies. So that's a reality in this one little market. This basic picture is true everywhere else, increasingly everywhere else in the political economy of the United States. This is true in news. Between the citizen as reporter, the citizen as the sort of publisher of newspapers, and the citizen as reader, there are two corporations that stand in between, Google and Facebook. And they manipulate the flow of information across their platforms. They warp that flow of information in ways that are designed to maximize revenue to themselves, but it results in a manipulation of the flow of information as a threat to the free expression by people and the free exchange of information by people, by citizens in the United States and increasingly in Europe. We really see this pretty much everywhere increasingly. The intermediaries are stepping into every single market in the United States and increasingly in Europe. Now, this community here at in Cpdp, your community, you tend to focus on issues around privacy. As Orla said, we focus on issues about the concentration of power, the structure of markets. As outsiders, the GDPR, we see this as a great advance. You guys should be proud of that. But it's important for you to understand that all of your regulations, all taken together, they are radically insufficient to deal with the problem that we see here today. Part of the problem, or sort of a fundamental part of the problem, is that European law, and in the United States, this is true in the United States, but European law focuses on the privacy of the citizen mainly in his or her capacity as a consumer. What it does not focus on closely is power. Power especially over the citizen as a producer. The GDPR does very little to address the main power of the platforms, which is to direct, to control the actions of the citizen as a maker of things, as a creator of things, as a thinker of thoughts.
Barry, if you could just wrap up a little bit so we can,
So I'm just going to jump ahead to the point of, what are we going to do about this? And we'll talk about this in some detail later. What we're going to do is we're going to break up these companies. That's the solution that comes out of the toolbox of antitrust. We're going to break up Google. We're going to break up Amazon. We're going to break up Facebook. Of the parts that we can't break up, the natural monopolies, we're going to neutralize them. And we can talk more later about how we're going to do that, but this is the conversation in which it's very important that you guys take part in this.
All right, thank you. Thank you very much. Maurice, over to you.
All right. Thank you very much for inviting me. So to follow up on what Barry has mentioned, we talk about in two of our books, Virtual Competition and Big Data and Competition Policy, about the rise of what we call the super platforms, and GAFA, Google, Apple, Facebook, and Amazon. We also talk about how data can provide these companies with power. And the thing I'd like to talk with you today is the next generation, and that's the personal digital assistant. And what you see, interestingly enough, is the rise of these super platforms, and now they're all vying to get their digital assistant in your home. And that presumably is good. I mean, there's competition here to have either Alexa, Siri, Google Home to be your personal assistant. One thing that we noted, however, is that in this market, there are these things called network effects. And network effects are not necessarily bad. They can be good. Basically, your utility goes up when other people use that product, just like a telephone. And here, with these digital assistants, we identify at least 5 network effects. And that means then that as more people use a particular digital butler, the more popular it will likely become, the greater its market share, and the more power it will have. So what are then the implications if we have a dominant digital butler? Let's say Amazon's Alexa becomes the overwhelming favorite. And here what we've cataloged are, there are 3 categories of harm. The first are traditional economic harms, and Barry touched on this a little bit before, that first are the economic harms upstream. So people that might try to reach you, they now have to deal with this gatekeeper, a toll keeper, that can charge the upstream suppliers a fee in order to reach you. Also, now they could favor their own goods or services to the disadvantage of others, and you've seen this in the Google search case that the European Commission brought. There's also impact as they collect so much data about you, they can not only predict your likes and wants, they can also get a pretty good sense of how much you're willing to pay. So you might see the rise then of price discrimination, where some of you might be paying a higher price than others. The second bucket of concerns involve privacy concerns. I remember when I raised this in Germany, there was talk about the Stasi Barbie. And I said, the Stasi Barbie is going to be small in comparison to this, because now you're going to have this device that's in your home that's collecting all this information about you, but then also collecting information when you're on the platform elsewhere. So when you're texting, looking at a YouTube video elsewhere on the platform, it's also collecting that data and data from third parties, and it's going to be immense. In one criminal case, Amazon mentioned that its digital assistant has basically the ability to recreate your life with the data that's stored on it. And then the third and final category are the social and political concerns. And here again, Barry touched upon this, is you're going to have a gatekeeper that's going to affect largely the news that you receive, the entertainment that you watch, and can then affect not only your viewpoint, but can also affect elections. And what then are the concerns in having this dominant digital assistant? And the key takeaway that I would like to leave you with, and we can discuss this more in the Q&A, is that market forces will not necessarily correct this. You could have a company that could control the space for a long time period. And then what are the implications when that arises? Thank you.
Thank you very much, Maurice. And we will obviously come back with Q&A from Orla later on. And over to you, Lina.
Thank you. So I'm going to be talking a little bit. I study market competition issues with a particular focus on the tech platforms, and I look at how are these businesses structured and what is the actual source of their power? And what a lot of my work tries to do is try to draw analogies with previous instances in which we've confronted analogous problems so that we can identify what are the legal tools that we've used in the past to tackle these forms of power and make sure that they're compatible with democracy. So I think oftentimes there is a sense that these new tech platforms are inevitable, that these are just the metaphysical forces of progress that have acted, and how we have these fantastic new technologies that also happen to concentrate a lot of control, and that's just the way it is. But in fact, there are a whole host of ways in which our laws and our legal regimes and the intellectual framework that we use to assess competition policy have actually had us go in one direction and not in another. So I think it's important to remember that when we're kind of talking about the level of control and power that the platforms have consolidated, that is not inevitable. It's actually a product of very conscious legal choices. So I'm going to just talk briefly about, what are the sources of power that these platforms now wield, and what are some of the ways that we've addressed these powers in the past. So I think a lot of the platforms share three main features. One is that they're gatekeepers. So as Maurice was mentioning, there are a lot of network effects that emerge in these situations, and so you have, one company that's basically now acting as this bottleneck. And what that means is that all of these other businesses, all of these other companies, in order to get to market, have to basically ride the rails of this single business. And these companies, Amazon, Facebook, Google, are able to use that power in very extortionary ways. The second key source of their power is the fact that they're integrated. So it's not just that they're railroads, but they actually own, the very goods and services that are riding their rails, and that puts them in direct competition with all of the companies that are depending on their platform. That creates a huge conflict of interest, which these companies are able to exploit, and they do exploit. The last source of power is the huge amount of data and information that they collect. Maurice touched on this in the context of, what are the ways in which they could use this information to price discriminate, to charge us all a different price for the same good. But another major consequence of this is the information asymmetry that's created between the monopoly and all of the other businesses that rely on its platform. So this is something that we see a lot with Amazon. Amazon is, this key online platform, but it also hosts other independent sellers that use its platform. And as a result, Amazon is basically able to use its third-party marketplace as a petri dish to see what goods are doing well, to see what products are selling. And what it ends up doing is it kind of swoops in and basically starts going into direct competition with those sellers. And so what that means is you have all these independent producers, all these independent sellers undertaking the original risk, bringing a product to market, and yet it's Amazon who basically is able to reap the reward of that risk. And you see a lot of sellers having to grapple with this. This is also something that we've seen in the context of Facebook. So a few years ago, Facebook acquired this technology called Anavo, which was kind of a privacy software that it's now using as a VPN. And in practice, what that allows Facebook to do is to track in very close detail what rival apps are diverting attention from Facebook. And what it's able to do is use that information to either go and make an aggressive bid to acquire this company, or to start copying and replicating all of its features to the expense of that company. And we've seen this happen with Snapchat, where Facebook has acted in this way. And so this is one instance in which these companies have amassed a structural and systemic advantage over all of the other companies in the economy, and are using that power to really thwart innovation and to stifle innovation. In the past, the ways in which we've addressed these challenges are, in the case of gatekeepers, we've embraced common carriage regimes, net neutrality type principles to make sure that the intermediary is neutralized. In the case of integration, we've actually mandated structural separations. So in the US, for example, when we saw the rise of the railroads, we also similarly saw railroads integrating in this way. They started buying up all these coal mining companies, and then would give their own coal an advantage. And so we passed a law that basically said railroads are not allowed to have an interest. They're not allowed to own any of the commodities that they're transporting, precisely to eliminate this conflict of interest that emerges. Lastly, we've also actually dealt with data and information asymmetries in the past. Admittedly, the scale at which these new companies have consolidated data is unprecedented. But one of my favorite examples is in the early 1900s, or the late 1800s rather, we saw the invention of the steam-powered grain elevator. And as a result of this new technology, you were able to see a lot of grain be consolidated in one place. So you saw single grain elevators basically capturing, holding all of the grain in a particular city. And what this meant was that the people who controlled the grain elevators suddenly had all of this information. What had in the past been grain that was distributed all across many elevators across the city was now instead consolidated in a single elevator. And they were able to use this information to manipulate markets, to basically place bets ahead of everybody else. And what happened was Chicago basically said that these grain elevators would have to allow public officials to come in and count the grain and make sure that that information stayed public. So I think, as we talk about the platforms, we talk about the challenges that they pose, it's worth remembering that we've tackled analogous problems in the past and actually have a rich set of legal tools that we can update to make sure that these technologies are serving the public.
Thank you very much, Lina. Christian, over to you.
Thanks, Liza. I'm going to make 2 points with a little bridge in between. We in EDPS, 4 years ago now, we were about to publish a report called Privacy and Competition in the Age of Big Data. What we were trying to do was launch a discussion on the synergies between these different areas of law, and we compared the objectives and found that they were largely coherent, but that the activities of the regulators were not coherent and tended to be characterized by silos. What we argue is that as far as data protection authorities are concerned, this is this topic here is of strategic interest. It's certainly a strategic obligation for DPAs to try to minimize harm arising from processing of personal information. It therefore makes strategic sense to try to stop, prevent the worst and most systemic offences. And over the last few years, following the publication of this paper, we've noticed a convergence of concerns about, on the one hand, concentration of market power, which has just been raised by my colleagues, and then on the other hand, a concentration of informational power. What we're also seeing in the last year or so is public discussion about addiction by design, the fact that devices and software have been consciously, deliberately designed in order to foster addiction in their users, in particular children. Now, what I think personally is that the debates around fake news, VPNs, ad blockers, etc., those are, you can almost understand them as proxy wars for control over attention, data, and freedom of expression, freedom to choose what sort of content you can see. So bringing this back to data protection, we're obviously delighted that the GDPR is on the statute book, and it will become fully applicable this year. The big headline has always been the fines. That's what gathers the most interest. But in fact, fines are not enough, and they never will be enough to change behavior. And the lessons are there from antitrust, from competition law, where they do have big fines, much bigger than even under the GDPR. But the power of antitrust as a discipline and as a regulatory arm is that it influences companies and that it stops harmful behavior. The fines are almost a reputational thing rather than actually interfering with becoming a financial issue, but it changes behavior. That's what I think the GDPR is aspiring to try to achieve as well. My second point is something more about antitrust and why we're interested in it. Antitrust is probably the most powerful arm, the administrative arm of the state. What we've noticed, however, is that in the way it's traditionally applied, there seems to be an obsession with price, with the notion of euros and cents, dollars and cents, as a way of analysing whether or not consumers are being harmed or not by particular behaviour. The problem is that in the digital reality that we're living, most people don't have to reach for their credit cards to interact via the internet. We need to have a more common understanding of what it means to consumer service, what transaction is being taking place, what is the actual price that is being paid. It could be that the price is disclosure of data. That's an obvious one for data protection authorities. It could also be the limitation on freedom to choose what sort of content you're going to see, or it could be limitations on what data you can move from one provider to another. What we do know from antitrust and from economics is that the more concentrated a market is, the higher the prices become. And it may be that what we're seeing in the concentration in digital markets is that the real price that's being extracted from people is getting greater and greater. So finally, what can be done? Why is antitrust of such interest? Well, there are two big things. The first is that antitrust can really, unlike the GDPR, even though there is a principle of scalability and risk assessment in there, antitrust more than anything else really goes after the big players. It goes after dominant undertakings, and it can change their behavior once it finds that something is abusive. And there are two forms of that. You can either exclude companies from entering a market that you're dominant in. There was last year on the panel that a few of us sat on, there was someone from a company called Disconnect, a startup in San Francisco, who had brought a case against Google as an antitrust case that they were providing a privacy by design application, but they were unable to get into the Android store because it was interfering with the predominant business model. The second way that you can go after dominant companies is exploitative abuse, and that's already been mentioned just now in relation to the Facebook case in Germany with the Bundeskartellamt, and that's going to be extremely important for data protection as well as for antitrust in the next year or two. And finally, mergers. We talk about concentration. There have been some high-profile big data mergers in the last few years. It started with Google DoubleClick, where this whole debate started 10 years ago, and it's gone through Facebook, WhatsApp, Microsoft, LinkedIn. We haven't quite got there yet, and that in terms of our analysis of what the longer-term potential harms are going to be to consumers, data subjects of these concentrations. And it's not simply about merging data sets. It's about the effect that it's going to have on people's freedom online. So that's where we think that data protection authorities, in alliance with consumer enforcers, can provide much more support to antitrust authorities.
Thanks, Christian. So if I'm to try and draw together a few of the thoughts that have emerged over these great kind of introductory pitches, I would say, first of all, as Christian has just said, every single speaker has highlighted the position of control exercised by certain tech firms, whether that's control of upstream, so of those with whom they interact from a business perspective, or downstream when it comes to citizens and the influence in things like political advertising, influence on elections, which we've heard a lot about over the past year or so. And we all seem to be reaching to competition law because, as Christian has just highlighted, it is the only legal instrument we have that somehow curtails or places a limitation on the exercise of power. But I guess my questions, because we have no doubters on the panel, so I'm going to play the role of the doubter today, and just ask a few questions about the limits of competition law in this context. And I know, Liza, you'll want to intervene at the end, because I could see you were edging to get in and say something on that. But first of all, competition law tends to be a very technical field. So we could start off with the kind of revolutionary spirit and say, break up all the monopolies. But in some ways, once you dig down, the devil is in the detail. And so it's a technical tool to deal with what are essentially becoming political issues. So I guess as a starting point, if we're talking about the breakup of tech firms, how do we identify which tech firms to break up? Do we have a scientific method of doing that? Or is it simply, if it looks like a monopoly and it acts like a monopoly, then it is a monopoly, and we could approach it in that way? would we risk being considered arbitrary in acting in that way? And then I guess I've got 4 more questions, and you can feel free to pick and choose which you'd like to deal with. But are we thinking too small by turning to competition law? So we want a legal instrument to regulate power. Competition law regulates and tackles economic power, but is it only economic power we're talking about here? So is it sufficient to focus on competition law, or are we right to turn to that because it's the only instrument that we have at present? And equally then, I guess, Maurice, you might be able to speak to this. The big pushback here from competition lawyers tends to be that this is shoehorning non-competition problems into the competition law framework. So they say, well, why not deal with environmental problems through competition law? Or if a merger, for instance, leads to redundancies, is that a competition law matter? So how as privacy advocates, those interested in a healthy market for personal data, or a healthy ecosystem rather than a market probably, how do we argue back against that kind of comment? And then finally, maybe Christian, you'd like to deal with this one. Are we having this discussion because data protection law has failed? So are we asking competition law to step in to avoid because data protection law hasn't been enforced effectively enough, perhaps, to deal with issues of power? So if data protection authorities had taken infringement proceedings against Facebook, would the Bundeskartellamt be doing the same thing? And finally, just one last one, and then we'll pass to the floor once you've had a chance to answer. What impact does the current political climate and political parties have on this? So what do you expect to see over the next year, particularly, I guess, in the US with the Trump administration? Where do you see them moving on tech issues? Because there have been quite a lot of allegations put forward about the Obama administration being quite cozy with big tech. So has something changed there? Okay, I'll leave that there, but Lisa, maybe if you'd like to comment first on the...
Yeah, thank you very much, Orla. In antitrust, we see 2 schools of thought developing. We see one camp that's very much in favor of what we call the Chicago school, which is very much that bigness may mean efficiency, and we should purely focus on efficiency in the economy. And then the other school of thought is the school of thought that are thinking that, well, could privacy and data and other kind of quality issues be considered under competition law, which Christian touched upon. And it's quite clear that there are certain limitations to antitrust, and one of the limitations is when consumers and citizens are getting something for free. So we have a zero-price market. Obviously, you all know in here that you pay with your data, so nothing is for free. But I'm just saying, when you don't pay a price, we have a zero-price market, and it has been very, very difficult for competition authorities traditionally to deal with that, because the focus, as Christian mentioned, has been on price. So how are we going to deal with this question of privacy and data? Well, there are other things we are thinking about in competition law, which is quality. And we could make that a quality issue in such a way that we would see companies, it's a quality issue if they don't provide a good privacy policy. But it's quite clear that the majority of these online platforms, they're getting their revenues from upstream, and therefore they don't necessarily think about quality downstream. So I think that we need to move away from a consumer welfare standard that focuses solely on price and move towards a wider way of looking at consumer welfare that considers quality and choice part of that.
I mean, I agree with what Lisa just said, and I actually want to tackle this issue of, are we thinking too small, this question that Orla just raised, by using anti-monopoly law. I'm going to kind of wave the American flag here for a little bit, and before I do that, I just want to say that since this is mainly a European audience, in recent years, you've mainly looked at the United States and you've seen empire, and you've seen a very bullying empire. But there is this other United States, and it's the United States of small d democracy. Really the cradle of small d democracy in this world. And, small d democracy in the United States has been connected to anti-monopoly from the very beginning of our country. And I say anti-monopoly, I don't say antitrust. And we can get back to this, the difference between anti-monopoly and antitrust. But small d democracy and anti-monopoly, we can trace it back to the Boston Tea Party in 1773. What was the Boston Tea Party? The Boston Tea Party was a bunch of people saying, we do not want the British East India Company coming in and telling us how to run our economy. We don't want the Boston Tea Party the British East India Company standing in between us as makers of things and buyers of things. We do not need an intermediary. We need liberty to engage directly with one another. The American Revolution was in large part a revolution against monopoly. From the beginning, Americans understood that fighting monopoly in the political economy was key to preservation of liberty, personal liberty. Over time, they came to understand that fighting monopoly in the political economy was key to the protection of our democratic institutions from concentrated wealth and concentrated control. Over time, people came to understand that anti-monopoly was the key to the preservation of our communities and the right to innovate, the ability to make the world better. So, what was the Chicago School? The Chicago School, libertarianism, neoliberalism, was what made the world a small place. They took us. Anti-monopoly was all focused on the interest of the citizen. The protection of small d democracy was all centered around the interest of the citizen in having open markets. What the Chicago School came along and they said, well, the citizen, that's not important. We're going to focus the entire political economy on serving the welfare of the consumer. And then they said, well, how do we achieve this? How do we serve the welfare of the consumer? It's through driving down prices. How do we drive down prices? We let people make bigger things, make corporations really big. We let them get efficient so they can drive down prices. Well, monopoly, complete control over some human activity or some other human activity. Well, if they're driving down prices, that's good for us because we're consumers. So what happened is we used to be big people. We used to have the world in our hands. We used to have control over our own destinies and over the destinies of our nation. And the Chicago Schoolers, the neoliberals came along. And they took that away from us. And how did they do that? They made us into consumers. And they built an entire body of law. They reframed the entire body of law that was designed to protect our liberty and democracy and our communities and our ability to make the world a better place. And they said, we're going to just focus all of this just on you as a consumer. And this way we're going to provide you with a few extra things at the end of the day. So I actually think anti-monopoly is absolutely sufficient to the task, as long as we understand that in anti-monopoly is the emancipation of us as a people, of us as individuals, from this idea that we are somehow consumers.
I'll tackle the first question about whether antitrust, which is a technical tool, is incapable of handling what seems like a political question. And I think that question actually gets to one of the fundamental problems, which is that antitrust is now perceived as this technocratic tool that is promoting efficiency. And the way that efficiency is perceived is as this kind of as this value neutral goal, whereas in fact there are a whole set of values embedded in what we mean by efficiency and how we measure efficiency. So I think we actually need to be thinking about anti-monopoly as a framework for how we structure our political economy, for how when we do see these new technological innovations, how we use the law to ensure that the balance of power is compatible with democracy. So I think it's actually, we first choose what are our political values, and then we see how those political values can be embedded in our legal institutions and the tools that we're using. So I think it's important to kind of go back to first principles, and I think that's why we've heard so many people mention consumer welfare, is because it's the philosophy underlying this legal regime is actually really key to what it is and isn't able to do. That said, I think, I think we also, when we used to think about antitrust and anti-monopoly in this more expansive way, we just had clear, bright line rules and kind of these certain structural principles that in fact made enforcement much more straightforward. Oftentimes now when you have a merger case or where you have an antitrust case, it's kind of just becomes this battle of economists where you have these competing studies, these competing calculations of what welfare looks like, and that in itself becomes very arbitrary. But in the past, we used to have clear principles, one of which, as I mentioned earlier, was if you are a network monopoly, you should not be able to use that power in discriminatory ways. There were strict limits on vertical integration to ensure that if you were a platform, you were not competing with the businesses that were dependent on you. And so I think if we embrace these principles, if we return to these principles, that itself will actually guide the way in a way that doesn't feel arbitrary.
Thanks, Lina. Maurice, maybe you could also, in addition to everything else you were going to say, just come to that point of how easy is it to turn back the clock and to return to these kind of first principles of antitrust?
Okay, so yeah, two points. The first is, well, just by a show of hands, how many of you are privacy specialists? Okay, now of those that are privacy specialists, just keep your hands up. How many of you also thought of antitrust before you came to this conference? All right, quite a few then. All right, so one thing, and this is largely credited to Christian to starting the debate, is what is the intersection between antitrust and privacy? And one of the things that we've concluded in our work is that there are some privacy matters that aren't antitrust concerns. So let's say a small firm had a data breach. That's a privacy issue, but not necessarily a competition issue. And there are competition issues that don't necessarily involve privacy. For example, cartels that fix prices doesn't really come into the privacy sphere. But there is an area, and that's what Christian sought out originally with its first workshop, is where do they intersect? And here, the positive news is you see a lot of development by the competition authorities, particularly in Europe. At first, they thought privacy isn't a competition issue. But then they've come to realize is that firms compete both on price and non-price, as Liza pointed out. And for non-price competition, quality has historically been recognized as an important component. And part of that quality is how firms protect your privacy and protect your data. And that can be an important component of competition, particularly where price is not a factor. And the European Commission now has come fully to realize that in the Microsoft LinkedIn decision. And in the United States, some of the enforcers are recognizing that as well. The second point is going back to first principles. And here, what a wonderful time to go back to first principles when you have an experiment. And as Barry pointed out, we've had an experiment with the Chicago School and post-Chicago School for the past 30, 35 years. And it's hard to see what impact competition policy has had, but if you look at the macro signs, you could see worrying signs. I mean, you can call them like storm clouds. And one storm cloud is, even though we have this consumer welfare standard, wealth inequality has increased dramatically over the past 35 years. The second thing that we've seen is that many industries have become highly concentrated, dominated by fewer market participants. And you also see a correlation is as industries become more concentrated, profits are accruing, greater profits are accruing to fewer hands. Third thing we're seeing is fewer startups. That's always been an engine of growth, dynamic efficiency. And startups are starting to decline as well. And then final storm cloud we're seeing is lack of worker mobility. You would think the opposite, but now it seems that we've been focused so much on consumers, we really haven't been focusing on how these mergers are impacting workers and the like. So antitrust goes in cycles, and I think now we're, with these storm clouds, with the view now that we're entering into this data-driven economy, and as several of the panelists point out, we have these price-centric tools that may not have been working that well in the brick-and-mortar world, and they have even greater problems in the data-driven world, that what a better time than for scholars to start looking at this afresh. And that's like the important work that Lina is having, and many of the other emerging scholars are raising now these questions that are looking at first principles.
All right, thank you. Lastly, I would like to hear from Christian, but I'm conscious that we only have 15 minutes left, and I'm really interested in hearing from you on the floor. So therefore, I will allow Christian to kind of wrap up and perhaps answer some of Orla's questions. But then I would very much like to hear from the floor.
I just got one question from Orla, I think. Has data protection failed? It reminds me of when I was at a reception and I bumped into a fairly senior official from DG Competition who kind of probably didn't want to talk to me. So he just patted me on the back and said, "Don't worry, we'll help you." Because he knew we were having these discussions. And he said to me, "Don't worry, we'll help you get your GDPR adopted." So there is a perception amongst the competition community that this is just the sort of data protection pygmies trying to ride on the back of the antitrust leviathan. Whereas in reality, we should be honest, the GDPR isn't enough. Data protection isn't enough because it provides a minimum standard, some consistent standards for what you do if you want to process personal information. If you really want to address inequalities, disparities, unfairness, which is prevalent in the economy where the dominant business model is monitoring everything that happens and keeping it for as long as you possibly can, then you need to use all of the tools in the toolbox. And one of the most powerful ones is antitrust for the reasons that we've been trying to describe.
All right, thank you very much, Christian. If I could please ask you to, those of you who would like to ask questions, can you please say who you are? And I'll leave it up to you whether you want to reveal your affiliation or not. Yeah, just go into the microphone and, yeah.
Okay. Well, thank you very much for that excellent panel. I appreciate very much that this topic is here at
Could you please
Cpdp.
say who you are?
I'm just on my way to do that. My name is Jan Schaderberg. I've been invited to the German Bundestag a couple of times. I'm a privacy lawyer to speak on these topics and on the issues at hand. And the question pretty much is on the tooling that we want to implement. And I still have difficulties in finding the right tool set. If we're looking into the structures, then we see the prevailing dominance of artificial intelligence mechanisms, where privacy law is not applicable because most of the times we're not even talking about personal information anymore or personal data. We have these learning systems, and I find it very hard to imagine how we can open up this information without revealing too much, with giving others access at the same time. And so I would be very interested in hearing from the speakers, from the panelists, how they envision to do that.
Thank you very much for that question. I will collect a couple of more questions before I hand over to the speakers.
My name is Rotem Medzini. I'm from the Hebrew University. And I have a question which is basically to Barry, but I would like to know the thoughts about it from the rest of the panel. And that is about the FTC as a regulator. On the one hand, it deals a lot with information and consumer protection, but it's also an anti-competitive regulator as well. And so my first question deals with the fact that he decided to go over against Facebook and Google with the consumer protection method and not the anti-competitive one. So the first question deals with that decision of him to go with one department and not the other. And the second one goes with the consent order they signed with Facebook and Google and the rest of the companies. And now that consent order that lasts for 20 years now, are going to affect your basic concept of using antitrust in order to influence consumer and those big giants corporation?
Thank you very much. Do we have any more questions? Yeah, let me take one more and then allow the speakers to answer those.
Thank you very much. My name is Janja Viskovic. I'm a data protection lawyer. I wanted to pick up on the addressing inequalities, unfairness and disparities requiring using all of the tools in the toolbox, and actually encourage us to also think outside of the toolbox, in the sense that in any ecosystem, and I think the natural environment illustrates this best, that in any ecosystem diversity is necessary for a healthy functioning of that system. And whether that diversity comes in the form of in terms of anti-competition and allowing smaller and medium enterprises into the market, or whether it's actually in terms of gender and ensuring that women are also getting equal access to funding so that they can create products and tools and reach the market, so that women are also designing AI, so that we aren't quite literally programming the tools of tomorrow with the very problems that we have been beset by in the analog society. And also, just looking around, this is actually a very white European conference, and it's also important to take into account other aspects of diversity to ensure that when we're addressing these inequalities in these systems, that we do so in a really inclusive manner, so that we don't perpetuate the issues that have beset our analog society.
Thank you very much. I would ask Maurice to answer the first question, Barry to answer the second question on the FTC, and Christian to answer the final question on inequality. And I hope we still have time for more questions from the floor. Over to you, Maurice.
All right, so that's a very good question. And in our book, Virtual Competition, we talk about the rise of an algorithm-driven economy. And they raise distinct problems from some of the issues that we're talking about here. For example, one thing that's very much captured the competition authorities' attention of late is, can computers collude, particularly when you have these pricing algorithms? And is there collusion within the reach of antitrust law? So there are a number of issues that can, and there are also issues involving non-personal data that also, where you might want to encourage the free flow of data, particularly among market participants. Related to that is, and your question addressed it, is that there are going to be trade-offs. There was this interesting case with the French Competition Authority where they found this utility company was abusing its dominant position by using the data that it collected on consumers to expand its power then in other markets. And then the issue for the Competition Authority is, all right, do we now give that personal data to competitors so that they can better compete? And you could see this trade-off between competition policy and privacy. And if you are going to allow it and you're going to have consumer consent, what sort of system is it going to be? Is it going to be opt-in? Do consumers expressly have to give their consent, which would favor the monopoly because presumably fewer people might then agree to? Or is it going to be opt-out, which is going to favor competition? And here you have the value of promoting competition that at times can clash with privacy. And we haven't yet really addressed how we're going to resolve that trade-off. And that's also going to be the case, for example, where you have these multi-sided platforms. A merger might benefit advertisers in better being able to reach consumers and identify consumers. But it could then harm consumers' privacy interests. So how are we going to then deal with those trade-offs? That's still unresolved.
As for the FTC, one way to understand American anti-monopoly enforcement for the last 35 years is that it's largely been absent. We should probably avoid focusing too much on sort of the technical decisions by the FTC and just, understand that the frame, the consumer welfare frame that was adopted for enforcement by the antitrust division of the Department of Justice and by the FTC back in the early 1980s, that has seriously restricted the ability of the citizens of the United States to use those two institutions to enforce anti-monopoly law. So it's like the enforcers have been walking around with a particular way of looking at the world that hides the abuse of power, and that hides all of these tools that are in the anti-monopoly toolbox from them. They look at the toolbox, it looks empty. They don't see the fist that they need to be dealing with. So as we start to wake up the enforcement community to the fact that the ways in which this ideology has blinded them, I think we're going to see we could see a pretty radically different attitude in both the FTC and the DOJ antitrust division.
The question about diversity is really interesting, because what we often say is that we're trying to translate our sort of analog values into the digital space, where they've tended to be neglected. But what about values and practices in the analog world, which we're not particularly pleased with, and we don't really want them to be replicated digitally? That's a very interesting point. We've been trying to promote an ethical approach to these questions, that ticking a box to say that you comply isn't sufficient to ensure that harm isn't going to take place. It goes right the way back to how software and devices are designed, and there need to be incentives in the market, and that's what the EU is trying to do with its legal reforms. There needs to be a strong stick, which is what data protection and certainly antitrust, as far as dominant undertakings are concerned, can help with. And there needs to be a genuine investment in privacy by design. And just one final thought, I mean, the AI is the buzzword this year, and there is enormous consolidation in AI. Startups are being acquired all the time. If you look at the last year, there's been a real spike in acquisitions and mergers. These AI is basically about crunching enormous amounts of personal data to try to replicate neural networks. But there comes a point where they just stop collecting personal data, and they just learn from within that sort of filter bubble. And so that's why there needs to be, at the design phase, there needs to be a real understanding of ethical values, regardless of what the law might say about data protection.
Thank you very much. We have another 5 minutes, so we have time for a couple of more questions.
Hi, Hadi Asghari, Delft University. I'd like to thank for the excellent panel. And so regarding this question of concentration of power, I would like to kind of ask if antitrust historically has worked, because I was reading about Standard Oil and how it was seen as a successful case, but the companies that resulted from that, Chevron, Exxon, they are still some of the biggest players, and how this other idea has been going around about the consent of the network, and how maybe the problem is that the billions of users of these platforms have no say in how the platform is, kind of which rules it's applying to them. And if we start thinking about it that way, then the solution will be to look at cooperative structures, or I mean, since you guys are thinking broad, I would like to hear your input on that. Thank you.
Hi, I'm Sebastian Dengler. I'm an economist at Tilburg Institute for Law, Technology and Society. And after having heard the rather bold prediction or claim or statement that you're going to break up the companies that are too big, and whatever is left over and can't be completely broken up due to the network effects, you're going to neutralize. I would like to hear whether you could maybe give us a hint of how you envision to do that, given the fact that not only due to the direct network effects, but also due to the indirect network effects that are at place, data-driven companies are starting to engage in markets that traditionally haven't been data-driven, such as car driving, and are going to be competitors for other rather large companies.
Hi, I'm Nadia Purto from Tilburg Institute for Law, Technology, Society, and I'm a data protection academic. My question is, well, could you please elaborate perhaps on the possibilities and limitations of the newly introduced right to data portability in GDPR in terms of breaking up monopolies? And I'm not talking about just shifting from Spotify to whatever other streaming service, but breaking up Google as a search engine monopoly, for instance.
Thank you very much. So the first two questions, I'll leave that to Lina and Barry, as I don't know, maybe Barry, you want to start on the first one, and then Lina go on the second, and then Christian, if you can answer the third question.
No, I think those are great questions, and I think the important thing for us to understand here is that this information economy is not really new. More than a century ago, with the rise of the railroads and very large corporations, one of the things that we saw, one of the things that people in society were very concerned about was the total sort of imbalance of power between the citizenry as a whole and the people who ran very large corporations in terms of the information they were able to master. There's a great series of works by Alfred Chandler who looks at the rise of the modern corporation. It's all about the mastery of information flows. And he looks at the railroads. So 100 years ago, this was a problem. It was at a different speed, but the relative mastery of information by the people inside the corporation, the people outside, is not new. So what did people do a century ago when they were dealing with natural monopolies, network monopolies, because the railroads were network monopolies. The telephone system was a network monopoly. The electrical system, it's a network monopoly. What did they do? First of all, they said, if you control a network monopoly, you will not use this. Lina was touching on this before. You will not use your power over this network monopoly to take control of unrelated lines of business. You can't leverage this to take over other lines of business. Number one, you will not vertically integrate. Two, you will basically charge everybody the same price and provide the same terms of service, and that will be published. There will be no backroom deals. And this is not just vis-a-vis the consumer, this is vis-a-vis the producer, the shipper, the creator. You publish and what you're going to charge, and you publish the terms of service, and that is audited and that is kept. So it's like everyone provides the same thing. You are a neutral provider of service. The third thing they did is they unbundled network monopolies. 1913, the AT&T, the telephone system, also controlled the telegraph system in the United States, Western Union. They unbundled them. They broke off the telegraph system from the telephone system. So how would this look like today? Well, one, Amazon, Google should not be engaged in any kind of business that is not related to their management of the monopolies, the network monopolies that they control. Two, the network monopolies, we're not going to try and break up the network monopolies. We're not going to try and break up search necessarily. We're not going to necessarily break up the platform where Amazon sells its books. But we are going to neutralize those platforms using the exact same tools that we used a century ago. We just had, with the FCC in the United States, we had the net neutrality decision in 2015. The basic principles are still alive. The basic principles are still being applied in the United States. We're going to apply those same principles to the platforms. So this is actually quite easy to do. There's nothing that is different fundamentally about these corporations. We just have to understand that it is in our power to achieve this. Once we understand that, we cease talking about, we no longer have to talk about, can we do this? Should we do this? And we will get down to the brass tacks of when are we going to do it and how are we going to do it?
I know
we're quite short of time, so a short answer would be appreciated.
Sure. On the first question about does antitrust work, I mean, I think it's worth remembering that the kind of reassembly of some of these big corporations resulted after the major shift in antitrust law. And so there were specific mergers that were permitted that allowed Exxon and Chevron to kind of reemerge as these immensely powerful companies. On the question about, do we need co-ops? What other forms of organization should we be thinking about? I think absolutely, anti-monopoly is really about reasserting the role of public power in structuring private power. But what that looks like in different contexts will vary. So, you know, I think there is a role for co-ops. I think there's a role for unions. I think there's a role for, you know, municipally owned services. So I think, you know, you can have anti-monopoly principles represented through different kinds of organizations.
Data portability is one area where the different regulatory arms like competition, consumer and data protection could come together quite usefully. We'll have to see what happens. It's all going to be dependent on companies being transparent about what information they actually have on people and whether they consider it to be technically possible to allow it to port from one provider to another. I'm not sure how germane it is to this discussion about monopolies, because a lot of the really big players already claim that they're implementing data portability.
Thank you very much. I hope you have all enjoyed this panel, so please show your gratitude to the speakers.